Hello friends, I welcome you all to today's lecture on Hindu law of adoption. The concept of sonship is very important for Hindus because they consider it necessary that their son should be in existence as liberator from hell and also to keep the lineal order intact. In order to ensure the existence of a son, they go for adoption of a male from a different family and endow it with the status of a real son. The doctrine of adoption is having religious as well as social sanction behind it. In this lecture, we will try to understand its legal position and need to keep this institution going. It will also be analyzed as to who can be adopted, what are the conditions for valid adoption, and what are the rights and obligations of an adopted son or daughter, etc. The doctrine of adoption has essentially a religious background, which has been in existence from the times immemorial. According to Manu, the adoption is important for every Hindu and has prescribed the manner of following it as under. He whom his father and mother give to another as his son, provided that the donor has no issue, if the boy was of the same class and affectionately disposed, is considered as a son given, the gift being confirmed by pouring water. Similarly, another authority on ancient Hindu religion, Vasistha, declares, "But let no man give or accept an only son, since he must remain to rise up a progeny for the funeral service of ancestors." Thus, adoption is the gift of a son by a family to another family as a substitute for failure of male issue in that family which is having religious sanctity behind it and sustains the philosophy of reincarnation amongst the Hindu. According to Mullah, a jurist, adoption can be described as under. Adoption is the admission of a stranger by birth to the privileges of a child by a legally recognized form of affiliation. The adopted son is then taken as being born in new family and he acquires rights, duties and status in the new family and his ties with the old family become severed. Adoption has certain religious characteristics. There were 12 kinds of sons recognized under the classical Hindu laws, of which 5 were those of adopted sons. The modern Hindu law recognized the Arusa or legitimate son begotten by a person from his lawfully wedded wife. Of the adopted sons, it recognized only 2 kinds, the Dattaka and the Kritrima. The Dattaka form prevailed all over India. The Kritrima form prevailed in Mithila and adjoining districts. The Hindu Adoption and Maintenance Act recognizes the adoption both of son and a daughter. Now friends, we will discuss the Hindu Adoption and Maintenance Act 1956. The Hindu Adoption and Maintenance Act 1956 is primary statute governing the law of adoption and contains a bundle of rules relating to validity, capacity and right of a male and female Hindu to take in adoption a son or a daughter who must be a Hindu. The word Hindu is an expression to be understood in the light of the comprehensive meaning given to it in the Act. It also deals with the subject of persons who may give in adoption and persons who may be taken in adoption. It also provides for certain forms of ceremonies to be followed for the sake of adoption. Section 5 of the Act makes it clear that after the commencement of this Act, no adoption can be permitted without following the provisions of this Act, and any adoption made hereafter shall be null and void in case it contravenes any provisions of the Act. An adoption which is void does not affect the status or rights of any of the parties. It creates no rights in favor of the adoptee boy or girl in the adoptive family, nor does the adoptee lose any rights in the family of his or her birth. The requirements of valid adoption. The requirements of valid adoption under the Act are: the person adopting must have the right to take the child in adoption, be lawfully capable of taking a son or daughter in adoption under Section 7 and 8 of the Act. The person adopted must be lawfully capable of being taken in adoption under Section 10 of the Act. The conditions relating to adoption, including actual giving and taking of the child, with the intention of transferring the child from the family of its birth, must be complied with in terms of Section 11 of the Act. Section 7 of the Act provides, Any male Hindu who is of sound mind and is not a minor has the capacity to take a son or daughter in adoption, provided that if he has a wife living, he shall not adopt except with the consent of his wife, unless the wife has completely and finally renounced the world, or has ceased to be a Hindu, or has been declared by a court of competent jurisdiction to be of unsound mind. Under Section 7 of the Act, a married male Hindu has to take his wife's consent for adopting a child, and in case of more than one wife, the consent of all the wives is required, unless the consent of the wife or wives is not necessary under the provisions of this Act. There is, however, no bar on a widow's right to take in adoption without consulting her co-widows. The issue came up for determination in Vijay Lakshmama versus B.T. Shankar, where a senior widow took a male child in adoption without consulting the junior widow. The adoption was challenged as being invalid. It was contended that the stipulation in the proviso to Section 7 with the explanation requiring consent of all wives should be read into Section 8 as well, which refers to the capacity of a female Hindu to take in adoption. The court, however, did not accept this plea and held that the deliberate omission as regards requirements of consent from a co or junior widow was an indication of Parliament's intention to give independent authority to a female in this matter. This is in keeping with the changing social set recognizing equal rights and status for women. The Apex Court observed, I quote, to subject the exercise of power by senior widow to adopt conditioned upon the consent of the junior widow, where the Hindu male died leaving behind two widows with no progeny of his own, would render the exercise of power more cumbersome and paradoxical, leaving at times such exercise of power to adopt only next to impossibility. That apart, the court held that in any case no injustice would be caused to a co-widow whose consent is not obtained nor required to be obtained by the law, since the adopted child would not divest any person of any estate vested in him or her before adoption. In this case, the husband had died in 1968, so under the provisions of Hindu Succession Act, all the widows inherited the properties in equal share. The adoption by one widow did not affect the share of the other widow. The court in this case referred to Narayana Swamy Naik versus Pangamal, decided by a division bench of the Madras High Court way back in 1905, where it was held that while for family peace and good relationship, a senior widow should do well to consult the younger one before adopting, but there is nothing in law which compels her to do so, and the adoption would be valid. Now friends, we will be discussing female's right to adoption. Under the Act, a female has a right to take in adoption without any legal infirmity. Section 8 of the Act reads, any female Hindu who is of sound mind, who is not a minor, and who is not married, or if married, whose marriage has not been dissolved, or whose husband is dead, or has completely and finally renounced the world, or has ceased to be a Hindu, or has been declared by a court of competent jurisdiction to be of unsound mind, has the capacity to take a son or daughter in adoption. This section brings about a very important and far-reaching change in the law of adoption, as hitherto applies in case of Hindus. It is competent now to a female Hindu who is of sound mind and has completed the age of 18 years to take a son or a daughter in adoption to herself, in her own right, provided she is not married or a widow or a legally divorcee, or if married, her husband has finally renounced the world, or ceased to be a Hindu, or has been declared to be of unsound mind by a court having jurisdiction to pass a declaratory decree to that effect. The Punjab and Haryana High Court had to deal with an interesting situation in Narinderjeet Kaur versus Union of India, wherein the issue raised was that of adoption by proxy and the effect of remarriage of a divorcee Hindu woman on her right to adopt. The facts briefly stated were thus: a divorced Hindu woman adopted a female child through her attorney and brother-in-law, in whose favor she had executed a special power of attorney. All the formalities of physically handing over by the natural parents and taking of child by the mother's attorney for being handed over to her and ceremonies were performed. A registered deed of adoption was also executed. The passport officer, however, refused to issue a new passport to the child with the adoptive mother's name, on the ground that an adoption made by proxy was not valid in Indian law. Later on, however, in the written statement, the defendant agreed that the law ministry had clarified that the child could be given or taken in adoption by parents, guardians under their authority. But a fresh objection was raised that the adoptive mother, having remarried, has no authority to adopt, and so passport for the child with the adoptive mother's name could not be issued. The court came to the conclusion that the respondent's plea was untenable, as the adoptive mother had remarried in 1994, whereas the adoption took place in 1990. Thus, her subsequent remarriage cannot invalidate the adoption. The adopted daughter was held entitled to a new passport with the name of the adoptive mother inserted in it. Capacity to give in adoption. Section 9 of the Act specifies the persons who are legally entitled to give a son or a daughter in adoption, does not make any substantial change in the law previously applicable to Hindus, except that under the previous law the only persons could lawfully give a son in adoption by his father and mother. The present section principally confines the capacity to give a son or daughter in adoption to the father and the mother of the child, but it also rules that where both the father and mother of the child are dead or disabled from exercising the right by reason of mental incapacity or renunciation of the world, etc., the guardian of the child can give the child in adoption with the previous permission of the court. In case of any violation committed by guardian under conditions stipulated in Section 9 of the Act, he can be punished under Section 17 of the Act. It may be noted that any agreement to give consideration for giving a son or a daughter in adoption contrary to public policy is amounting to trafficking in children. The Parliament has taken a serious view of the matter and prohibits in this section the giving and receiving of any payment or reward by any person in consideration of adoption of any person. Capacity of the person to be adopted. Section 10 of the Act specifies the person who are eligible under the Act to be adopted. The section reads, "No person shall be capable of being taken in adoption unless the following conditions are fulfilled, namely, he or she is a Hindu, he or she has not already been adopted, he or she has not been married unless there is a custom or usage applicable to the parties which permits persons who are married being taken in adoption. He or she has not completed the age of 15 years unless there is a custom or usage applicable to the parties which permits persons who have completed the age of 15 years being taken in adoption." The present section lays down some simple rules of uniform applicability to all Hindus, the expression Hindus being understood in the wide connotation given to it by section. Section 11 of Hindu Adoption and Maintenance Act 1956. Section 11 of the Act is a very significant section as it regulates the institution of adoption according to law, equity and justice. According to Section 11, in every adoption, the following conditions must be complied with. If the adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son, son or son living at the time of adoption. If the adoption is of a daughter, the adoptive father or mother by whom the adoption is made must not have a Hindu daughter or son's daughter living at the time of adoption. If the adoption is by a male and the person to be adopted is a female, the adoptive father is at least 21 years older than the person to be adopted. If the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. The same child may not be adopted simultaneously by two or more persons. The child to be adopted must be actually given and taken in adoption by the parents or guardian concerned or under their authority with intent to transfer the child from the family of its birth, or in case of an abandoned child or a child whose parentage is not known, from the place or family where it has been brought up to the family of its adoption. Effects of adoption. According to Section 12 of the Act, the adoption has certain vital effects which may be briefly enumerated as follows. Transferring of the adopted child from his or her natural family into the adoptive family. The child cannot marry any person whom he or she could not have married if he or she had continued in the family of his or her birth. Conferment of same rights on the adoptee as enjoined by the natural born child in the said family. The adoptee shall be deemed to have born in the adoptive family, and all his ties with his original family shall cease. Any property which vested in the adoptive child before the adoption shall continue to remain in such person subject to the obligation, if any, attached to the ownership of such property, including the obligation to maintain relation in the family of his or her birth. The adopted child shall not divest any person of any estate which vested in him or her before the adoption. While concluding, it may be said that doctrine of adoption is having both religious and social sanctity. Adoption is the admission of a stranger by birth to the privileges of a child by a legally recognized affiliation. The adopted son is then taken as being born in new family, and he acquires rights, duties and status in the new family, and his ties with the old family become severed. The Hindu Law of Adoption and Maintenance Act 1956 is primary statute governing the law of adoption and contains bundle of rules relating to validity, capacity and rights of Hindu male and female to take Hindu children in adoption. This act has given due right to females to adoption. With these words, I conclude today's lecture. Hope you have understood fully. Thank you.